Looks like this is on. Judge Scudder set it on for a review for refinancing of the home.
And that's correct, Judge. This was pursuant to a decree of dissolution that was entered last August, giving Ms. Stevenson 12 months to do so, set periodic reviews on that. This is the latest. I believe the existing order requires Ms. Stevenson to have either refinance the home by August 2nd or alternatively put the home up for sale. I haven't received any information since we were here a couple of months ago. But nonetheless, that's what we got. I can inform you that my client has not been contacted by any lending institutions to sign any papers to that effect. So we're, I guess, kind of awaiting word from Ms. Stevenson on what her plan is moving forward.
Right. Ms. Stevenson, any information?
Hi, can you hear me okay?
Yeah, I can.
Okay. No, I'm still just trying in the process of the refinancing. I'm just having troubles doing so. So I'm just trying to figure out my best options still.
Okay.
Really, I'm getting to the last of the wire, but.
Yeah, I have August 1st is the deadline. So if we don't have a refinance by August 1st, the order requires that it be placed for sale at that point in time.
Yeah.
So
yes, I understand. Yes.
Do we want to set a review? I don't see another review currently set. Do we want to set a review for the 25th of July?
I'd rather do it, Judge, I think for after August 1st. So that way we'll know whether it's been refinanced or not. We can just kind of advance to the next stage of that order, which would be listing it for sale. So maybe the first or second Tuesday in August, as available in Ms. Stevenson's schedule, I will make work.
We have August 1st or August 8th.
Well, I prefer the 8th.
All right. All right. So Ms. Stevenson, we're going to set a final review for August 8th, 2023, 1 p.m.
Okay.
Obviously, if you get it refinanced prior to that,
Yes.
you can get that information to Mr. Zandy, then we can get
Yes.
rid of that hearing date.
Yes.
If not, then we'll review it on the 8th for
Okay.
the next steps. Okay.
All right. Thank you.
All right. Thank you.
Thank you.
Here I am.
You're Gary Rapp.
Hello?
Hello.
Yes, I am.
All right. Thank you.
Hello.
Okay. We're here in 223-004-0508 to review whether the income and bank statements were provided to Mr. Zandy. So Mr. Zandy, where are we at?
I have not reviewed any income statements or bank statements or the like from the result of the last hearing. And I can tell the court that by our calculations, as of this past weekend, Mr. Rapp was behind about $8,800. He's paid a total of $3,200. Court has expressed its reluctance to some of the excuses that have previously been ordered and discussed by Mr. Rapp. I do understand he recently paid $400 in cash. I think that might have been this morning, but we continue to go backwards in this. We do have a settlement conference for later this month that we are going to be proposing some ways in which he pay her directly out of various assets that will likely be allocated to him or potentially allocated to him. But no, I mean, it's much of the same. This is now the third time we've been here. We have sporadic incomplete payments that are made the day of or a day or two before the hearing that, again, do not comply with the existing order from last fall and affirmed by at least 4 different judicial officers now. So it's the same frustration for my client. We have not gotten compliance from Mr. Rapp, and I do not believe that he has provided my office with anything. And if he did, that was very recently.
All right. I'm showing that Commissioner Nelson on the 23rd ordered Mr. Rapp to provide all information, or excuse me, provide information of all his income and bank statements for the last 3 months to Mr. Zandy by June 13th with a review on the same date. So Mr. Rapp, have you provided that information to Mr. Zandy's office?
I didn't realize I had to give it to Mr. Zandy, but I have all the paperwork right here in front of me. I've got copies of it last month and month before.
So you have your income and bank statements for the last 3 months. Can you get those to his office today?
Yes, I can.
All right, because that's what I'm showing. The ruling of Commissioner Nelson was when we were last here on the 23rd. So
I misunderstood him. I have them all right in front of me, so that's no problem.
perfect. So I appreciate that, Mr. Rapp. So you have an upcoming MSC, Mr. Zandy? Looks like it's in this month.
I believe it's June 29th. Don't quote me on that. I'd have to look at my calendar. I didn't bring it with me, but I think it is later this month. My suggestion would be, if we can't reach a resolution at that time, maybe set this out to late July to see what efforts have been made. Now I can strike that hearing if we do reach a resolution here in a couple of weeks.
You want to set that? You want to set that today? for review?
Yes, please. I think that makes sense.
All right. How about we can do either the 18th of July or the 25th of July?
Let's do the 18th.
All right. So Mr. Rapp, and you are correct, Mr. Zandy, there's the settlement conference is set for the 29th of June. And then we'll set a review on this docket for July 18th at 1:00 p.m. And then Mr. Rapp, if you can make sure to get those documents to Mr. Zandy's office before close of business today, I would greatly appreciate it.
Okay, that was 6:18.
7:18 at 1 p.m.
I mean, 7:18, I'm sorry. At 1:00.
Yes, sir.
All right.
All right.
Appreciate it.
Thank you.
I will give him all the paperwork.
Thank you very much. I appreciate it. And this is a request, looks like to modify child support.
Correct, Your Honor.
All right. I've reviewed everything, but I'm happy to hear any argument if there's brief argument.
I'll try and keep it brief, Your Honor. Thank you. John Quittner for the petitioner, Amanda Duke. And we are asking the court to set aside the temporary child support order that was entered in late November, set a new amount based on the respondent's true income, and order child support, post-secondary, that is child support for the oldest daughter that's just turned 18. We're asking for attorney fees. As to whether the court thinks that contempt is appropriate, we're leaving to the court. We did not motion for contempt. So this is based on the respondent, Mr. Duke, to our mind, deliberately undercounting his income. And if we jump right to deliberately, it's because we have a lot of experience with this. I've been doing this with the Dukes for 7 years, and it's always been the same. He's failed to disclose not only a substantial raise that he received 2 weeks after filing his income numbers, he's also failed to report several things that are required to be disclosed to the court. That's, in this case, investment accounts, real property, the income of a spouse, owning several vehicles, a boat, an RV, 6 automobiles, whereas my client owns pretty much nothing. And so this is, when we're going to talk about the percentages of income that make us, that give us the obligations for our children, this all needs to be known. Mr. Duke came back, responded that, we had to go out and subpoena his pay records to find that his income was triple what he had recorded or reported to the court. Every time he changes a job, and he has done it now twice, he's required by law to update that information with the court. He's done so neither time. In the last hearing where we got our temporary order, he's responded that, well, we talked about the then pending raise, and the court took that into consideration. Well, it worked for the court at that time because it was spoken about in very vague terms. Oh yeah, I don't know, it's got a raise coming. Well, it was a raise that pretty well tripled his income, and he would have been much happier had no one ever found that out. We gave them a chance to disclose it. We waited, nothing happened. We had to subpoena it. So that happened in, I believe, January. Now he's back saying, oh, weird, because in January, I took a new job. I took a pay cut. I had really good reasons for doing that. And we think that's a ruse. He's been doing this for a long time. They know we have the correct numbers. And, all this time, they're also trying to get rulings from Division of Child Support, trying to hurry up and get rulings for child support for the child that Mr. Duke has. Each of the parties here has one child in their custody. Mr. Duke has represented in his responsive pleadings that the boy that lives with him has these problems with his mom and won't speak to her and stuff. I think it would surprise Mr. Duke to know that the son actually speaks to his mom daily. He doesn't want his father to know about it because his father would.
Right. Judge, I would just object to anything that's not in the pleadings. We're getting well beyond the scope of the declarations at this point.
Yeah, I would agree. I don't really think that has anything to do with child support, but continue, Mr. Quittner.
Fair enough. Thank you. So we've been doing this with Mr. Duke for a long time. And, before I got here 7 years ago, he had just dictated what the child support was going to be. And it was going to be completely, away from the courts. This whole thing has been a real drain on Ms. Duke's meager income. She's a home health aide. She has 2 small children at home, receives child support for neither one of them. Not that we're asking Mr. Duke to subsidize that. But Mr. Duke does suggest that, she needs to look for better employment. Easier said than done when you've got 2 small children at home and not a whole lot of help. It's not realistic. Meanwhile, as it's in the pleadings, Alyssa Duke, now 18, has just turned 18, will be living at home and attending community college. Mr. Duke has the resources. We're asking that he pay post-secondary and support her in that. I saw his response that, I'm glad that he's, we're heartened that he's willing to address it anyway. He had just said that, well, maybe 1/3 should be apportioned to the child, and the remaining proportions according to the percentages of income that the parents have. I would just assume that he supported her completely and allow her to save some money. So that's it. In sum, we're asking to set aside the last order, enter a new amount of child support set at nunc pro tunc to back to, I believe, September. Use our calculations. Remember that the court is not bound by the standard economic table, and order post-secondary and attorney fees in the amount of $2,000.
I
should
noticed,
say as well that. Should I continue?
yes, go ahead.
Last sentence, last subject. That we're at the youngest child who's now living with Mr. Duke. I think it would be appropriate that Ms. Duke be apportioned the state minimum of $50 a month child support if she's going to pay for that child. And that's it, Your Honor. I'm sorry.
I noticed that in the child support worksheets that were utilized by the court in November, and then the ones proposed by you now, not only there's a difference in Mr.'s income, but there's a difference in Mrs. income. So is she just imputed at full-time minimum wage and under your most recent order?
No, we didn't impute, Your Honor. Those are her real numbers.
Okay. All right, Mr. Zandy.
And I appreciate it, Your Honors. Of course, where I do represent the respondent, Joseph Duke. And initially, I would just, again, I didn't want to interject, but I would object to a lot of the requests and comments of Mr. Quittner as they're not made in the motion, number one. And number two, I think they far exceed the scope of the law in this. Again, we're here, and my client filed a petition to modify the parenting plan back in early September. I believe it was on the 2nd of 2022. That time we had filed a significant amount of pay stubs, income information. We had addressed the fact that he was getting a military retirement, which Mrs. Duke is also getting an arm of that, which I'll discuss momentarily, and told the court in very uncertain terms that he was expecting a promotion at then Horizon, but we didn't have any information to provide because, again, that was in process of being tweaked. That was considered by Judge Scudder at the time. That was argued at length between counsel and I, and that has never been something that's anybody has sat on their hands related to that. He was promoted back in October. I believe it was mid-October of 2022. That was after we had the hearing. Again, this is on a petition to modify the parenting plan. We filed that at the onset of September because school was starting and my client had a then 15 or 16-year-old child in his primary care. So there's nothing nefarious about this. There's nothing unusual about this. This is commonly the case. Parties change jobs, parties get raises, parties get cost of living increases during the pendency of modifications and divorces and parenting plan actions, and there's nothing unusual about this. Didn't see in the motion filed by Mr. Quittner on his client's behalf any request to go back in the motion itself and set this to November. I would say that is grossly inequitable and not supported by the law. Again, this is a case where Judge Scudder considered several arguments, considered the RV calculation, considered the fact that there was the 2021 tax return, which Ms. Duke improperly claimed the children. He didn't rule on that by design. There was also the fact of the request of my client of the whole family deviation for a child born from another relationship in Indiana. Court didn't give him credit for that. And basically, as we sometimes do as a blunt instrument on temporary orders, said, get the information, collect it, and you can come back. And that's essentially what we've done. Very short time later, Mr. Quittner and I again have a conversation. We've had several, and those are always good. I've never had an issue communicating with him in which we discuss the subpoenas, the increase in pay, and that's what we have. So it's not by surprise. It's not by deceit. This has been addressed from the very onset of this case. Court considered that, applied what Judge Scudder had at the time, figured out the RV calculation, and here we are. Again, this is still a pending petition on my client's behalf. And we then get a petition, which I don't think is procedurally correct, to modify the child support that was already under an issue of the original petition. My client files a response to that. We get a request to address the relief today without an accompanying motion. So we show up a couple of weeks ago, I believe it was on the 23rd, without anything to really go off of. My client pays for the time there. that point, it was understood that we would be getting a forthcoming motion in the interim, set it out to today's date. And we don't get that again until June 1st or 2nd, which gave my client very little time to respond to that. So from the procedural standpoint, again, I think this is not properly before the court, and the request certainly isn't appropriate. Court did acknowledge that my client did in fact have primary custody of Cameron. Cameron just completed his, I believe, freshman year at Kelso High School. Remains in my client's care and custody. Child is doing well. Recognize the fact that Alyssa, the now 18-year-old, was finishing her senior year with mom. Thus, the RV calculation ordered that my client, as an offset of the incomes, pay $602 per month in support. Again, considering all these factors, again, being cognizant and aware of the fact that my client will be getting a raise. So that's the jumping off point. If we look at, again, this notion that it was deceitful, I've already given you my assessment on that. My client has detailed that at length. No, we just simply do not believe that is proper. Again, there was no information to provide because we didn't have it. We were shooting in the dark, had no idea how much he was going to be making. At the time of the filing last summer, my client was making $58.66 per hour. That's what was used. He also had access to this military retirement. Again, that was calculated in the support obligation, and Judge Scudder used the incomes accordingly. So that's kind of the easy part of this. Now we get to some of the misgivings in the existing motion and declaration from Ms. Duke. And again, we are completely off on the valuation of the incomes. They're asking to go back in time and impute him at a captain's rate, which he wasn't making at the time of the hearing. They're also asking to impute him at a captain's rate, in which is not reflective of the very numbers that they provided. If you look at the pay information provided by Ms. Duke under sealed, you'll see that my client had net income between the months of October of 2022 and December of 2022 in the amount of $24,169, or a net of $8,056 per month. So again, this is the incorrection is that she's assuming that he works 40 hours a week like a normal job, and he tells you that's not how the airline industry works. So that's first and foremost. It is true that in January of 2023, he took a job at American. American, and again, as provided in his declaration, provides much better plans, much better income long-term, much better benefits than Horizon does. It was a logical choice, but they're on seniority. So if you look at what he was making at the time of the hearing of that $58.66 an hour, now making $90.93 per hour. So obviously there's benefits. He will be able to be on the captain's track again, but he tells you it's a seniority-based system. The fact that it's better benefits, better medical, better 401k contribution, and matches by the company makes it a logical choice. And again, that's subject to very simple inquiry of pay stubs, employment contracts, and the like, as opposed to ask for that in typical discovery, which we have and would have provided more if requested. Ms. Duke decides to seek a subpoena, which again, that's her choice. Nobody's gotten in the way of that, but the information is all the same. My client tells you at the time that there are FAA regulations required of having basically, I want to say a drive along, but a fly along with the FAA. There's simulator tests. There's a number of hours. It's basically the education that he started back in October to get to the point where he was. Now the credentials don't go away. He's been, again, he has those. Now it's just up to American to put him back into the captain's seat as opposed to a first captain, which he currently is at that $90.93 per hour. I've calculated his income based on the minimum guarantees, which the airline offers. Again, he's the low man on the totem pole because it is a seniority-based system. That's guaranteed of 75 to 79 hours per month. I used the high end of that. I took the $90.93 times 79 hours per month. I've included his wages that he gets from the military retirement. It bumps his monthly gross to $9,483. And again, I think for a gross income, that's not too far off on what the court did last fall. The issue we have is the information or the lack thereof on Mrs. Duke's behalf. To suggest that she only paid $50 per month for a 16-year-old student, in addition to having my client pay 100% of the post-secondary for a college-age student, again, is just grossly inappropriate and not substantiated by the statute. We've given you information, and it's undisputed that she's getting the sum of, I believe, $1,159 per month from my client's military pension. She could also choose to work full-time. It sounds like she's in some kind of a care capacity. We didn't calculate her at that income. The fact she has 2 other children, again, that was not pled. I can't respond to that. But nonetheless, just imputing her at full-time minimum wage of $15.74 an hour, when we could argue that it's $20 an hour plus because she lives, I believe, in the King County area. We didn't do that. Leaves her with a gross income of $3,866 per month. And again, that's full-time minimum wage at the $15.74 in addition to the $1,159 from the military retirement. That is what it is. That's the number that should be plugged into the child support worksheets. As it relates to this post-secondary request, again, I don't necessarily agree with counsel's assertion of what the statute and requirements are related to providing pay stubs continuously throughout the pendency of an action. But nonetheless, Mrs. hasn't done that. We have no information related to job searches. We have no information related to actual earnings. We have no information related to that other than the request of, I want to be imputed at the what convicts are currently paying who are incarcerated at $50 per month, even though I have resources and choose essentially to be underemployed. Post-secondary, again, dovetails that. We have zero information provided by Mrs. Duke as to what Alyssa will be pursuing. We have a generic email from Olympic Community College that says, congratulations, you're basically accepted. We have nothing else required by the statute related to that. We don't have any kind of scholarship information. We have no financial aid information. We have no income pertaining to Alyssa or her working part-time. We have no plans. This is the first we heard that, well, she's going to be living with mom. This is the first we heard of that. We don't know whether she's going to go full-time or part-time or in what course of study she's pursuing or the like. Most importantly, we don't have any FAFSA information. That's the federal aid that is required in all admissions in which they go off of any financial aid, who the primary parent's household income is, and they give grants accordingly. We have none of that information. We've done what we can. We looked up the Olympic website and pulled what we could. And it's, again, typical of most community colleges, requires that a child who's going full-time, which is defined as 12 credits, it's $1,197 per year, an additional $708 for books and supplies for in-state tuition. That's what we have. And again, we have nothing to confirm that. So just to say, okay, well, Mr. Duke's going to pay for college. We have no direction on what that even means at this point, because we have a child who, it sounds like, applied at Olympic and a mother who has provided absolutely zero information related to that, which we absolutely need to put that in an order. We look at my client's request, and again, he's thrilled that Alyssa is pursuing her college education. We think that's fantastic. But there needs to be some design by this. There needs to be some functions of the order that are going to apply to this child. And specifically, we need to know that she's in good academic standing. She should provide evidence of that on a quarterly basis. We need to know what classes she's taking. We need to have access to her grades on a quarterly basis, all her financial records, so that my client knows what he's paying to who and for what. If she drops out of school or she takes a quarter off or a semester off, obviously the parent's obligation should cease. And Mr. Quittner is right. What we're suggesting is simply an equitable resolution to that, that the child is responsible for the first third. Again, that's what we traditionally do in Cowlitz County and throughout the state. The parents are dependent for the remaining 2/3, again, of the tuition, the institution fees, and the books. And I think that's very reasonable in this. And those 2/3 are broken up according to percentage of incomes, again, as you set today. There should be separate order. Now the RV calculation goes away as the child is quasi-dependent, now going to school at Olympic, presumably. We need to enter a transfer amount for Cameron, who will be, I believe, a sophomore or junior at Kelso this year. There needs to be a separate contribution from mom towards that. My client has paid 100% of those obligations since the child came to live with him a little over a year ago, in addition to the $602 per month as set by the court back in the fall of last year. We need to now differentiate the order. Post-secondary should go under one paragraph with, as we have proposed, and the child support transfer for Cameron should go under the obligor section of that order, again, as supported by law. If you are considering attorney's fees, again, we don't think that's appropriate. And we think there is much simpler manners in which we could have gotten to this point. I've already detailed those for the court. My client has in his declaration as well. But to suggest there was some procedural issues in this case would be an understatement. And again, that's all coming at a cost to my client, who has been forced to respond unnecessarily to that, and also the local rules that were somewhat violated. In any event, we will leave that up to your honor if you believe that's appropriate. But we simply do not believe contributing to Miss Duke's somewhat scavenger hunt is certainly appropriate or necessary given the facts of this case.
All right.
Just a couple of quick remarks in rebuttal, Your Honor.
Very quickly.
Thank you. I will make them quick. I did ask for non-protonc back to September in the pleadings. That's at page 4 of the motion for temporary family law order. Item number 2.
I saw it. Go ahead.
Thank you. And that law that you're looking for that requires you to get current when changes are made is 2623-050 subsection 5M1. That If you're going to change jobs, you disclose that in the new confidential information forms. That's all.
All right, well, this is clearly kind of a mess. It appears though Judge Scudder had a lot of this information when the termination in November was made. The job wasn't switched until January. Here we are. And now essentially the child that the support is due is 18. And so any support moving forward would be for post-secondary. Even though I know that there's a request for the support to essentially go backwards to September. I've reviewed the worksheets. I've reviewed the financial information that's been submitted. Let me first start with the post-secondary support. It sounds as though Dad is not in opposition of providing post-secondary support to the eldest child, assuming we get the information they need. That seems reasonable. All we have is you got accepted. We don't know, that doesn't appear that any information has been shared about when it starts, what, I guess I'm not going to repeat everything that Mr. Zandy is requesting. I think all that is necessary. I'm sure both parties are very aware of 2619-090 that outlines what's required in post-secondary educational support awards. And I think that money would either go straight to the child or to the school, to those direct payments. As far as the last, from September until now and readjusting, I'm denying that request. My hope is that can be some additional exchange in information between the parties regarding post-secondary support, and that can be sorted out. If it cannot, then I'm happy to make a determination on that once it's noted up. But I'm denying the request to nunc-pro-tunc, go back to September of last year. I don't think the financial information warrants that. Arguably, if you would have asked from February until now, maybe, but the fact that there's supposed to be a cross payment that doesn't appear to be happening, so I'm denying the request. So if you want to note this on for in a few weeks to see if you can do that, or if you just want to do a docket notice, either way works. I'll defer.
So that's fine, Judge. Hopefully Mr. Quittner and I can work that out. As it pertains to the support for Cameron, the 16-year-old still in my client's custody, you want us to run numbers for that child based on whatever incomes you give us, or what's the court's directive on that?
Well, it appears that Mr. Zandy, you did not, only Mr. Quittner's submitted a child support worksheet. Is that correct?
That's correct, because I could have probably given you 20 of them based on all these figures and possible scenarios. And if I'm to be blunt, I didn't think that seemed like a real valuable use of time, which is why we kind of in the declaration just pinpointed specifically what we thought the incomes should be, as opposed to just giving you various worksheets with different figures that would have needed an hour's worth of explanation. And we've also suggested that effective start date be July 1, 2023, again, to give us a clean line on what's expected. We can include in that new order the post-secondary language under paragraph, I believe, 17. And then under the standard calculation and transfer payment, I believe it's under paragraph 6 or 8 for Cameron. So Alyssa would be under that paragraph for post-secondary, Cameron under the paragraph for.
Well, it appears to me, sorry, the numbers that in the responsive declaration and based on my review appeared to be appropriate was the gross for Mr. at 9483. That's including the military retirement. So if we want to run those numbers, and if there's an agreement to that, then great. Otherwise, that can be reviewed when if we need to review post-secondary support.
And how about for Mrs. Duke?
So I guess there's 1159 is what one party is claiming is the military, her portion of what she receives from the military retirement. And it appears in her proposed child's worksheet, she's indicating 1066. So that's about $100 difference. I don't know.
Fine with the 1066. I don't think that's worth necessarily arguing over, but do you want to impute her at an income, or what's the court's directive on that?
I would, at this point, yes, impute her at full-time minimum wage plus the 1066.
Very Lebanese breakfast, perfect for my 2 and 4 year
Miss
olds.
Corey, I'm going to mute you. So we'll if the parties want a date now, I'm happy to set one. If you want to note it up, if you can't come to a resolution, that's fine as well.
Can we note that up for that July 11th date? That'll give us some time to work through it.
Sure.
If you're available, Mr. Whitner.
Checking, thank you. July 11th, I should be fine. Yeah, thank you.
All right, so July 11th, and we'll set that for post-secondary support and any transfer payments. So that'll hopefully cover anything that the parties need to raise.
Based on the information you gave us today. Yeah,
Yes.
fair enough. So presentation/review.
Correct.
Okay, thank you. Matter's
All right,
ready,
thank
Judge.
Is Mr. Jones going to be here, or?
I sent him an email last week, not pertaining necessarily to this hearing, but about other issues. We set this back at the time of the original temporary order hearing a month or so ago. I haven't heard from him. I expected him to be here, but I don't see him on the Zoom roster.
Well, we have Miss Height. So this is just for the interim GAL review. Have you been able to make contact with the parties?
Making sure I'm unmuted here. Yes, I have been able to meet with the parties. I had a home visit with mother. I have one scheduled with father and the boys, and they are both up to speed on their payments. And so I'm underway. Don't have anything particular to report to the court right now.
Okay. Mr. Zandy, are you comfortable just considering that everybody's in compliance with GAL? Looks like we have a final GAL review of September 12th that's set.
Yeah.
Need anything else?
No, that's short and sweet for me today.
Perfect.
Except the last case.
Yep.
Thank you.
All right. Thank you.
Noel McLean appearing on behalf of the petitioner, Lena Fisher.
We have a Michael Fisher present. All right. And for the record, nobody in the waiting room. Looks like this was on, there was a contempt and just a review of a CR 26I.
Well, asking the court to schedule a CR 26I since Mr. Fisher would not communicate or cooperate with me in that regard.
All right.
I have not received responsive documentation to either of these motions. I've outlined in my client's declaration the efforts that we made in regards to securing discovery answers from Mr. Fisher. We sent him correspondence back on May 9th to schedule a CR 26I on May 16th. He didn't call me. I tried to call him. I left him a detailed voicemail. I will tell to the court that after we filed our documentation on May 22nd, Mr. Fisher did reach out to my legal assistant on May 23rd, indicating that he wanted to know what we were looking for from him. I did respond back to that email on May 30th and attached the discovery the discovery request, our cover letter, and the prior certificate of service. And I've heard nothing. I've received no discovery. He's not made any calls to my office, and he's not responded to that email. So I'm asking the court to sign my order, which would set a CR 26I deadline date of June 21 by 12 noon for him to deliver completed discovery answers to my office.
I guess my one concern is that he's not here today. Presumably got notice back on May 24th of this hearing. No response has been filed. He's not present here today, not in the waiting room, not responding when called by the court. The 21st is just a quick turnaround, I guess, is my concern. But I also understand that if he's not really done anything in the last 6 months, I understand the concern. So I will give it all that.
I apologize for interrupting. I just wanted to let you know that I have had contact with Mr. Fisher. I don't know if you want to know about that.
I don't think that has anything to do with discovery at this point, but it does potentially with the other portion that we'll deal with. So I'll sign the order scheduling the CR 26I with the due date of the 21st at noon.
Thank you.
All right. And then go ahead, Ms. Height.
I had a couple of phone contacts with Mr. Fisher, and I will tell you he's had through the course of this time, he has been in the hospital 3 separate times. So I know that is somewhat thwarting. He also has very sketchy phone contact. When we spoke on the phone over a period of probably 45 minutes, the call dropped multiple times. So I don't know. I'm not making excuses for him by any means. I'm just saying my contact with him was difficult to achieve. He did want to be heard, but he's not here. So And I do know that he knew that we had court time today.
All right. I appreciate that, Ms. Height. As to the contempt, which is essentially accessing funds that in opposition to the temporary family law order, I've reviewed that information. Any brief statements, Ms. McLean, on that?
The only other thing that I would point out is that there is both a protection order entered in another cause number, as well as a no contact restraining order that's in effect in this case. Your Honor signed that back on March 14th. And so he's to have absolutely no contact with my client or the children absent court order or appropriate communications. He did mail to Apollo the gaming equipment, which would be a third-party contact in violation of those orders. And what's concerning is that clearly my client is a victim of domestic violence. There's been a finding of domestic violence for the court to enter a DVPO for a year that protects both her and the children. His continued financial abuse is indicative of his ongoing domestic violence. And we're asking the court to grant the order as requested. That provides for reimbursement of the unauthorized withdrawals of $1,713.47. That period is through, I believe it's through April 30th. We're also asking the court to order $200 in sanctions and $750 in attorney's fees. I would remind the court that at the time of your initial oral ruling on February 14th, he was advised not to remove monies from that account. He was also, we had a colloquy on the record at the presentation on March, I think it was March 4th, yes, on March 14th. And he assured that he wasn't removing monies from the account, even though I outlined my concerns with the records that I had seen at that point. And yet he's continued to do so, which removes funds that are available for my client and these two children. And I remind the court that my client is a stay-at-home mother providing for homeschooling for both of these children.
All right. I've reviewed the information with no response. I will make a finding of contempt. I'm going to adopt your order, except I'm going to strike the civil penalty. So I'll impose the lawyer's fees and the 1713.47 withdrawal. I made the changes in both sections and I've signed off on that order.
Okay.
The last thing I want to address, Ms. Height, we're back in 2 weeks for final GAL report. Are you on track for that? Since we're here, I just thought I'd ask.
No,
Did Your Honor receive the filing that I made on the 8th of June? I filed a brief document in lieu of a final report asking for more time and seeking some more independent information. I do not recall a case in which there has been.
Well, Your Honor, I guess I'm not prepared to discuss the GAL, her interim report, and I have documentation that's coming in response to the allegations.
Okay, I just didn't, I forgot that this was in there, Ms. Height, so I apologize. I just know that we've had a lot of GALs running a little bit behind and thought I would ask now, but if I do see this and I do recall now reviewing it, so we'll leave it on for the 27th.
Okay, thank you very much, Your Honor.
Okay.
All right.
So just to be clear, you want a report, a GAO report on the 27th, or previous so that it can be reviewed on the 27th?
We're going to review it. If you don't have all the information you feel like you need, you're free to ask for an extension at that point.
All right.
So I don't want you to put something together that you don't feel is complete or this was filed by
I will
the
do my very
petitioner in
best,
this
Your Honor.
case.
Thank you.
There was a motion for contempt based on an allegation that on May 24th, 2023, the respondent and another individual were in a vehicle with the two children after the time frame that that individual was not supposed to be around the children. Am I getting that correct, Mr. Bierbauer?
Yes, Your Honor.
Okay. And then I did also receive the response. So, Mr. Bierbauer, do you have any additional information or any argument you'd like to make at this point?
I didn't receive or know anything about a response information. I don't know if I was supposed to email that to me or I haven't got anything.
Mr. Hawkins, you're representing Ms. Bierbauer?
Yes,
And was that response provided to Mr. Bierbauer?
I believe so, but I'd also like to note that he never provided us his motion. we have never been served with that. And so I just wait.
That was an honest mistake.
And if not, we can send him the documents, but I believe they should have been sent to him.
Well,
I have not received any emails.
All right, hold on one second. Are both parties available next Tuesday afternoon?
Yeah, I have
That would be
time off
the
work again.
20th at 1 p.m. Well, if you want to move forward without knowing what her response is, we can do that.
I don't know what the response is or anything because I haven't received anything.
I understand that. I'm offering you an opportunity to review that before we move forward, or you can move forward now without.
I'm available next Tuesday.
Right. Mr. Hawkins, are you?
Yes, I am.
All right. Then let's set this over 1 week to the 20th at 1 p.m. And then if parties can make sure to get any information that you want to argue before the court to each other by Thursday close of business. And it sounds like if emailing works best for everyone, given the tight time frame, then let's have it be that way so everybody knows what everybody's position is.
Okay.
All right.
Would you ask Mr. Hawkins to please include me in any information he sends out?
If you could do that, Mr. Hawkins, it looks like you
Yes.
still have an active GAL in this case.
Yes, will do.
All right.
Thank you for reminding me.
I appreciate your patience. Let's have you come back next Tuesday, the 20th at 1 p.m. And I'll try to, I'll make a note to get you called as quickly as I can at the beginning of the docket.
All right. Thank you, Your Honor.
Later in the day is fine for me.
All right. All right. Thank you both. We'll see you. Good afternoon. Okay, we're here on, it looks like a review for visitation.
Correct.
All right. Okay, I've reviewed everything. It's like there wasn't, the only thing that was filed after the hearing was continued on the 23rd was the monthly summary from Ms. Bliss. Is that correct?
Correct.
Okay, just wanted to make sure that I did not miss anything. All right. Counsel, whomever wants to start, any argument?
I'll go since I guess it's my initial motion, if that's okay with you, Mr. Swenson.
Yes, go ahead.
Okay, thank you. So Judge, we're back before the court on just a review. Your Honor had set this date to kind of see how visitation had been going since our April 4th hearing. I'll just remind the court in my initial requests for that April hearing, I had essentially requested a phase up schedule. At the time, my client was having supervised by Ms. Evans's mother visits once per week for a span of 3 hours. Your Honor expanded the visits to unsupervised, but maintained the same time frame and schedule. My client provides in his recent declaration that the visits have been going great, contrary to Ms. Evans's declaration. The child is happy, healthy, being able to reconnect with his paternal family, whom he's been separated for a substantial period of time. And at this point, my client is asking for expanded visitation. Again, I'll remind the court that Your Honor had set that schedule and set this review to kind of see how things have been going. I did not see any significant concerns reported in Ms. Evans's declaration. There wasn't any safety concerns or anything of the like, which was the initial case. So at this point, we are asking for expanded visitation. Depending on what Your Honor wants to do, I would just reflect back to my March 13 motion where I kind of laid out a schedule. If Your Honor wanted to go based on that, I was proposing a increase to 6 hours of visitation for a period of a few weeks, then increasing to 10 hours of visitation for a few weeks, and then beginning overnight visits. Again, acknowledging the fact that a slow transition is probably warranted in this case. So that would be my proposal, or if Your Honor is willing to go beyond that, my client is more than happy to accept whatever visitation Your Honor is willing to provide.
My client has severe anxiety about the expansion of visitation with Mr. Heinzman. This court has found enough evidence to issue a domestic violence protection order protecting my client and the child against Mr. Heinzman. While this visitation has been on this schedule for about 2 months now. The only concerning behavior, because it's unsupervised, has been that the child has been stating, "I hate you, Gabby," after visitation began, which is concerning behavior. So we just ask that the court remind the parties not to speak poorly or allow anybody else to speak poorly about the other parents in front of the child. Right now, that's all we have, and that the visitation be slowly increased, if increased at all, due to the allegations. Thank you.
All right, thank you. So right now, sorry, this was a funky order. So we're first 2 Saturdays and third and fourth Wednesdays, 9 to 12. So it's been 3 hours, essentially 6 hours a week. That, or no,
3 hours a week,
3 hours a week.
or 4 weeks. Yes.
And let's see, hold on. We have a young child. I understand the concerns with increasing visitation, and I do agree that should be done in a very slow and measured way. And let me see here. It appears that there's been continued cooperation, and the most recent report from Miss Lovely is, I think there's one area that it was just satisfactory. Everything else is a consistent and, progressive way that he's going through his treatment. Miss Bliss, can you, March, what was the date that you?
That was my March 10 motion and declaration, I think, which is what prompted this action, the motion and declaration to modify visitation schedule. And if you look at page, of course, I don't have any page numbers on this. 1, 2, 3. The last page of my client's declaration where his signature is contains that proposal.
Okay. Here's what I'm going to do. I'm going to adjust the phases a little bit. And obviously, if there's any issues that can be raised at any point in time, but we've been about 2 months on the current plan, 3 months on the current plan. I understand the concerns with the I hate you, Gabby comment. That is concerning. However, there's no indication that's necessarily a dad directed comment. I will ask the attorneys to direct their clients to not have any disparaging comments about the other in front of this young child who's very impressionable. I'm going to kind of adopt Ms. Bliss's formally proposed phasing plan. So what I'd like to do, but instead of 4 weeks, I'm going to do 6 weeks. So same first 2 Saturdays, third and fourth Wednesdays will increase to 6 hours. So 9 to 3. That'll be for 6 weeks. If all of those are completed successfully, then the next phase will be 10 hours, 9 to 7, same days for 6 weeks. So that I'd like to stop there. And I don't know, I don't want to babysit this case more. The next phase is overnights. And I guess, Mr. Swenson, based on your client's concerns and trepidation, do you want to have a review after those 2 phases before we automatically go into overnights?
Yes, please, Your Honor. Just in case there's anything that pops up between then and 12 weeks from now, or now from 12 weeks.
So let's set this for let's set a review for September 19th. And that'll be at 1 p.m. If everything's good, I fully anticipate implementing overnights at that point in time. Obviously, if there's any issues or concerns from either side prior to September 19th, I'm happy to review it before then. But that at least gives us kind of, this is the point we're aiming for, where things are going to maybe look a lot different because of the overnight portion.
Okay.
And if you parties can agree to an order and present it ex parte, that's great. Otherwise, do we need a presentation date, or do we think we can do that?
I think Mr. Swenson and I could probably figure it out. Yeah.
All right. Thank you. All right. Let me ask a question. Well, good afternoon, both of you. Sorry.
Good afternoon.
I saved you for last because it's kind of there's a lot going on.
Understandable.
So I have a modify temporary orders, an evaluation request, and then a moving and a prevent to move issue. So are those the 3 areas we're looking at today?
That's correct, Your Honor.
Okay.
And Your Honor, I do have a preliminary motion to strike child hearsay, and I only address it now because your decision on it may limit our argument significantly.
I'm fine to take preliminary issues first if you want to, Your Honor. And I have a suggestion just to cut to the quick of the issue. And that is both parties used substantial amounts of child hearsay. I can point to declarations submitted by the respondent that are hearsay within hearsay. I think Your Honor knows how to deal with that pretty efficiently. And so given that, and given that both parties, if counsel wants to keep it out, great, but that keeps out entire declarations of hers.
And I guess
again, Your Honor can, I think, make reasonable, otherwise we're gonna go line by line and spend a lot of time, because then my response is great, let's go through all these other declarations too, because there's hearsay and hearsay within hearsay.
And Your Honor, I disagree. Basically, this whole declaration is the child said this, and father argues that these statements are true. That is hearsay. The statements I attribute to the child in my declaration, we do not agree that they're true. They're not. They're absolutely not true. It was the fact that the child said it that was the point. It's not offered as the truth of the matter asserted. Father, his whole declaration and his whole basis for objection to relocation is based on statements he says that the child said, and he is saying that they're true. We disagree.
Is the I'm 99% sure I know what I'm going to do in this case. But I want to ask a clarifying question specifically about the move. I think I'm able to determine what I should consider and what I should not consider. So I'm not going to consider any hearsay statements, regardless if they're from a child or otherwise. Where is, I understand it's Kath Lammett, correct, that the move is being requested to. And is there, is that to an apartment, a home? Because one of the declarations indicated it was an RV on property. So I just want to clarify where the intent to move. I don't need a specific address. I'm just asking what type of a residence will they be moving to?
And Your Honor, that is represented in the photos that father submitted. It's a manufactured home on acreage. It is 4 bedrooms, 2 baths. It is owned by mother's father. And the pictures of the RV and the debris, that's on the neighbor's property. It's not even related to the place in question. I don't know where the camper came from. There's no camper. It's a house.
Okay. The other question I have is there's been kind of some reference to GAL. Do both parties agree a GAL is appropriate?
We agree to reappoint the GAL, Your Honor.
I agree.
And we would just ask that it be at father's expense.
And that's inappropriate.
Who did we have before? Ms. Corey, were you previously the GAL? Okay.
Yeah, that was me.
All right. And I did not look this up. I don't know how long ago you were discharged and where you're going to need to, let's see. It looks like a report was filed late last year. So you're only about 6 or 7 months out of the loop here. Okay. That's good.
Actually, the attorneys and the parties have kept me in the loop pretty well. So
good.
I don't have much catching up to do.
That's excellent. Okay. So I'm gonna reappoint Miss Corey. And it sounds like she'll be able to hit the ground running.
You come in here or conference room?
I don't believe, let me just, looks like I have some proposed by Miss Baldwin. I have temporary order regarding relocation and a parenting plan from Miss Baldwin only.
And I just left some big blanks in there too, just so that you had space to craft as you wanted.
I just want to make sure that and Ms. Jeffers, you haven't proposed any orders or sent any originals at this point.
That's correct, Your Honor. I mean, at this point, I'm just requesting to go back to the previous order I think that Ms. Baldwin, since there's so many blanks on her proposed order, that will address the relocation issue. And I think she left a blank space if the court even wants to address the GAL issue in that. With regard to the other motion, you haven't got to it yet, and a proposed parenting plan. I usually wait for decisions on that. If you prefer that I send that in advance, just let me know and I'll be sure to do so in the future.
I don't necessarily have a preference. I just was making sure I had everything in front of me that I was supposed to have. So I'm going to apportion the GAL payment the same as the temporary order of child support. So proportional pay. And here's where I'm at. So there is a lot of back and forth between these parties in these declarations. There's a lot of concerns that the court has. Frankly, I think everyone's being a bit ridiculous. There's Mr. Rance's time that he spent in prison. Frankly, I don't even know what the underlying charges on that were, but clearly that is impacting Miss Vick. And I think moving forward, the parties need to try to focus on how that can be minimized for any impact on the child with the child's safety and well-being in place. So frankly, at this point, let me see. I always think I make the excellent notes for myself, and then there's like little gaps so I know that we have parenting plan schedule in place. So
It's not happening though. So my client's now being denied.
So, let me finish. I did notice, and I will ask for some input on this. It did appear as though the reference to me saying keep the counselor in the loop effectively eliminated a visitation or has eliminated some visitations. Is that?
I disagree. This is so when you're ready, I can argue more fully on that, but it is not Mrs. Rosen's fault that visits are being denied.
I'm not claiming Miss Rosen's fault, but it sounds like since there wasn't a meeting when mom set a meeting, then is that why visitation stopped?
No, Your Honor, and this doesn't really need to be argued. What happened is the child expressed some issues with visitation. He went to Miss Rosen. Miss Rosen recommended that the pickup for the exchange for the next visitation be in her office so she can discuss those issues. Father and child, Miss Rosen, were all present for that meeting, and Miss Rosen was unable to convince the child to leave with father. That's what happened.
And we would dispute. Essentially, we had visits that were going fine. There was the objection to the relocation filed. Suddenly, visits are not going fine. And suddenly the child is expressing, if you look in the materials that are filed, Ms. Rosen never says there's a problem with my client. She says child's making disclosures. Both parents are telling Ms. Rosen things, and Ms. Rosen is sort of saying, I don't know what's real and what's not real. And the child isn't expressing any of those things to her. So those are not, that's essentially what her email states. So then we have a situation where then child's not going with my client, even though that's the court order. And I think we're sort of using Ms. Rosen as an excuse that mother is still taking child away or not driving away. It's a situation where my client is not being allowed to parent. And if your honor's ready for further argument, I think Ms. Rosen's own letter is the best reference you have for this. So Ms. Rosen's letter.
Is that the February letter?
Yeah, that's a February letter, Your Honor. And
Okay.
I just indicate that the email for Ms. Rosen.
Okay, stop. I'm not changing the parenting plan. It's staying how it is, period. I'm appointing a GAL. Child needs to remain in counseling. If he has any issues with any of this moving forward, that's his resource. As far as concerns with the move, I understand dad is opposed to the move. I'm going to grant a temporary move. I'm not going to, and then I guess if the parties agree to change the pickup location, I believe it's currently in Ridgefield.
Woodland.
Is it Woodland? Okay. If there's an agreement to change that, fine. Otherwise, it remains in Woodland. And then I guess we just need to set a date for when we want any additional information from Miss Corey.
That's fine, Your Honor. And I would just ask for some guidance. I mean, do you want my client to just have the child dropped off at the Safeway and just leave him there? Because right now, according to Ms. Rosen's email, he refuses to go. And mother's not even the one providing transportation. He's been left by a family friend at the Ms. Rosen's office so that she can facilitate the transfer and convince him to go, and it's not working. So if the court says that my client needs to have him dropped off at a location in Woodland at a Safeway and just leave him there, that's what'll happen. But I need clarification because father's going to claim this is all mother when the child says, I don't want to go.
This is the problem, unfortunately, with the gamesmanship that's happening. My client, because of the allegations, he's kind of like, I'm not going to touch anybody kind of a situation. So he's not going to open anybody's car door because mom's going to immediately claim domestic violence. She did that previously. In this case, like during the pendency of the current action, as far as if he does anything, and the pleadings that she has in the court file now are, he look at his behavior. So my client's being super careful and reasonably so. This is a situation where the people that are dropping the child off all have a vested interest in the visitation not working. So it's all people that mother claims essentially are co-parents with her. It's either her live-in boyfriend or the ex-boyfriend who she claims has the child every other weekend. So these are all people with a vested interest in this not going well. And I think that inherently is part of the problem is we have these people who are not going to encourage the child to really get out of the car. It's kind of like, gee, kid, if you want to go, you can go. But that child's in an impossible situation where to do so, he's biting the hand that feeds him. He's biting essentially his mother's hand, and that's his only house right now. And so that child doesn't have a lot of options. So in this case, that's my significant concern for the child. I would ask that the mother have someone drop the child off who frankly she can't drive, so it won't be her, or she doesn't have a driver's license, and that it not be her current boyfriend, who have concerns regarding domestic violence with, or the alleged sort of stepfather, her prior boyfriend. Again, they all have some weird vested interests in this not going well.
And I disagree, Your Honor. I just asked, Ms. Baldwin, are you asking that the child be dropped off in Woodland and left there? If that's what you want, that is what will happen.
Okay, so you're wanting me to say, yeah, leave a 12-year-old child all by themselves at a Safeway in the middle of wherever that's nowhere that they have family that lives. That's unreasonable. Here's the thing. We're adults. Are we not adults? These individuals are adults. They have children. They need to figure this out. If they want me to dictate every single moment of their lives, hey, I'm happy to do that. We'll set a full day and I'll do that. But they need to step up, act like adults. This child has two parents, and this man has a right to be involved. He's gone through a year of reunification counseling with no issues, mind you. And now all of a sudden, there's all these things that are coming out that frankly don't have a lot of basis. I am concerned that these folks can't figure out how to exchange a child so a dad can get a few hours a week with him. That's concerning.
I understand, Your Honor. Even the counselor couldn't figure it out. So I'm not sure what to do here.
I don't want the child to be placed in an unsafe situation. I don't want him left if dad isn't there. If the parties agree that we try Miss Rosen's office for the next couple exchanges.
Agreed.
But it shouldn't mean that the kid doesn't get to do the visitation and dad gets missed out on the visitation.
Here's what I propose. I don't want the child I don't want to create a game where the child's encouraged to run either. That's not a good solution. What I probably propose in this situation is the court order drop off to begin the other person's time, which is sort of the reverse of what we usually do, but that require essentially mother's designee drop off at my client's address. My client will drop off at mother's address. It's a rural property. Essentially you can drop off at the end of the driveway. You have the pictures, so there shouldn't be any issues there. He doesn't have to drive up the driveway. He can literally pop the kid out on like the side of the road. But that sort of resolves the problem because then child's being left at a home on both sides. It's not my preference as far as it's not ideal, but I think that's honestly the best solution because what the request is, let's go back to Rosen. That's already failed twice. So that's not working. I think that we're using that now as a method of validating a missed visit instead of it being a problem-solving solution. At some point, we've done that for a year. That's not the right solution. I think there's a lot going on in the background for this kid. So that's, I think, a reasonable solution that will effectuate the visit you've ordered and sort of require both parents to effectively transfer the child without the gamesmanship.
And I kind of disagree on that one, Your Honor. That's just a long round trip for either party, quite frankly. And I don't know how that prevents anything, quite frankly. If the child's not going to get into father's car, he's not going to walk into father's house.
Then dad'll have to deal with that.
I think the concern is, so it's very weird from my perspective, obviously, and likely yours, since we're all outsiders to these folks' situation. We're not accompanying them to these drop-offs and pickups. When a child essentially refuses to attend a visitation, it is a ripe situation for one of the parties to claim bad actions by the other. And it slices both ways. So Mr. Rance could make the claim against Miss Vick or whomever the misters are that have been ferrying the child to pickups and vice versa. Frankly, given the current state, I don't know that I can dictate who Miss Vick, if Miss Vick doesn't drive, she's in a predicament where she's relying on other parties. I'm not going to dictate who she gets to do these transfers. I am going to, and I want it in the order that Mr. Rance is allowed to open the car door. So I want the exchanges to happen where they're supposed to happen. Child's not to be left without the other party present and accepting that child. Mr. Rance can open the car door and ask the child to come with them without there being any issues. If the child, frankly, I'm not going to sit here and decide what's going to happen based on what the child's response to that is. If the child refuses and Mr. Rance as a parent picks the child up and puts him in his car, I'm not saying that's an automatic contempt. There should, if there's reasonable parenting involved there. Children, unfortunately, don't always get to dictate when and where they go. That's especially true in situations where there's multiple parents and they don't live together. But Mr. Rance should be allowed to do that. Conversely, Miss Vick should be allowed to do that if child isn't wanting to get out of the car when Mr. Rance drops off.
And Your Honor, I would just ask that instead of opening up the door, my client will have the child out of the car. That's not an issue. I mean, he is getting out already and going to father. That's not a problem. Instead of dad randomly walking up to people's cars and opening up their
then why are we even having this discussion? I thought you said the child's not refusing to go. Was that just because it was at Miss Rosin's office?
Yeah, we haven't tried this outside of Miss Rosin. Miss Rosin was going to help facilitate the transfer to dad. So it was just Miss Rosin, the child, and dad.
Okay, well, let's, I guess then I'm not going to try to solve a problem that doesn't exist yet. So transfers in Woodland.
And I would just be, they should be clear. If they kick us out of the car, the other person needs to drive away. Why are there? We should not be creating.
As long as dad is there. I mean,
yeah, sure. Yeah, absolutely. Yeah. It's just the idea that we're sort of like literally like putting the puppy between two people and leaving both car doors open. It's like.
No, I was under the impression that this was happening beyond at Miss Rosin's office. If it's child's willing to go with dad and get out of the car, then there shouldn't be an issue. But the child shouldn't be left unattended at the Woodland Safeway. Okay, so and then if the parties agree to change the location to the McMenamins and Kalama or whatever, based on the move to Cathlamet, I'm fine with that. But I'm not gonna change it unless it's agreed by the parties. All right. Any I guess Miss Corey, since you're clearly there's a lot of turmoil in this case, you're relatively up to date. How? And this is going, I guess I'm asking all three of you, do we want to set a GAL? Do we want to just do a final? Do we want an interim?
I would like an interim. We were supposed to be kind of doing that anyway. I'm trying to remember now if we have a date in August or if we were going to set one. So I would ask that we have something out in August. The idea was that if originally when you set this calendar, it was kind of like if there's any time left in the summer and we don't know if there will be, then we can note it back on to address some more extended time. So we kind of had that, if not the idea, if not an actual date, we had the idea of having it pinned back in anyway in August. So that would be kind of my thought. If Ms. Corey doesn't have a final done by that time, that's certainly reasonable. But I think input at that time is reasonable because at that point we would have sort of completed the schedule that you've laid out.
Okay, so we have August 1, 8, 15.
I'm out the first week of August.
I am also.
Okay. So August, the first full week of August or just?
First full week, Your Honor.
So the 15th of August, would that work for everyone?
That's fine.
That works for me.
Okay. So let's review for August 15th at 1 p.m. Sorry, go ahead, Ms. Corey.
Can I clarify then? You're looking for a final review in August or an interim review in August? Final review if it's done, and if not, an interim. Did I understand you correctly, Ms. Baldwin?
That's my understanding. Obviously if it's done, fantastic. But if it's not, there's a lot of allocations, and we're also dealing now with the relocation. And so you're tasked with all of those things. So that's not giving you a whole lot of time. It's only giving you really a month-ish to get all of that information done. So my guess is you'll only have an interim done by that point.
That would be my guess too. And could the order appointing maybe have some specific points, issues that the current issues that we're looking at detailed, please? I don't know which one of you is doing
Well,
it.
that's a great question because it just, frankly, it seems like everything's at issue at this point. There's domestic violence back and forth, accusations is, by respondent to petitioner, and petitioner alleging that between respondent and other domestic partners. There's issues with the child in school, but arguably a new school would be started with the move. So there's a.
Would it be fair to say that just looking at pleadings since my report?
I think probably even especially since, frankly, there's been a boatload since April. I think April forward. And then I know that there was a request for an evaluation by respondent of petitioner. And what I will say is I'm going to authorize the GAL to make any requests for evaluations of either party as part of the investigation.
Without bringing that back to court, or?
Correct.
Okay.
Is there putting a dollar limit on those though?
Yeah, I think Ms. Corey, my hope would be that she would be not asking for a full, psychosexual polygraph examination, those, $3,500 things that take, 9 months to get done. So within reason. So if it's something other than a standard DV eval or standard SUD eval or, something along those lines, I guess I'd want you to bring that back before the court.
Okay.
And so then we'll I'm going to call it an interim GAL review for August 15th at, hold on. Yes, August 15th at 1 p.m. If the orders are, if we have agreed orders, great. Otherwise, I don't know if you want to set a presentation for orders. My next week I have very little on next Tuesday for some reason. And then I have Fridays at 8:45.
That's on Friday. I'm not available next week, but I am available Friday. We could either do this Friday or next Friday. Both
Can't do Fridays, Your Honor, until at least July 14th for me.
Let's see. I could do the 27th. I just can't do next week.
Let's take a look. I can do the 27th as well. And just to clarify orders, I'm going to, Your Honor, you have the relocation order. So you need an order, the GAL order. Is that it?
I need a GAL order. I guess I don't know if the parenting plan that, I guess that you're in agreement with the parenting plan that Ms. Baldwin proposed.
You said the current parenting plan, Your Honor. So I'm assuming we're sticking with the current parenting plan.
We already have one of those entered?
Yes. Oh, yeah.
Sorry, I moved to the 27th to look. The 27th is currently closed.
Take us to July 11. I can do July 11.
I can do July 11 as well. And I mean, also, Your Honor, I mean, if you just want Ms. Baldwin to prepare the GAL orders, I'm totally fine with just sending you written objections and have you enter the order as you see fit.
If Ms. Baldwin agrees with that, I'm happy to do it that way. And then we don't have to set a review other than the August.
That's fine.
Okay.
So,
and then the temporary order of moving was from Ms. Baldwin, and all the language is
denial.
Is a denial. So I don't know.
Okay. She sent me something else that was blank. So I assume that was what it was.
No, it is, but it's denied. And then there's big blanks in it for other relief. So that's the same order the judge is looking at.
If you want to do the same process for that,
yes.
If you can't agree on it, then I'm happy to just do those ex parte once I receive everything.
Perfect. And just procedurally, my suggestion is that Ms. Jefferson, I'll just consolidate all of those. And once we have them, we will send them to you as like a bundle. So you don't have to guess on whether or not you have it all. You'll just get them as a packet.
That sounds fair.
That's fine.
So I will shred the two proposed that you sent, Ms. Baldwin, and await the bundle.
Yes.
Thank you, Your Honor. Thank you.
All right. Thank you all. See you August.